My name is Abhishek. I'm a legal intern at LEXIS and Company. So today's my topic is FARIDKOT rural property dispute. So before proceeding with the topic, I request you please like, share and subscribe the channel LEXCLIQ. So the Punjab and Haryana High Court judgment upheld the property rights of the woman in the family of last Maharaja of FARIDKOT. So now let us talk about who was the last Maharaja of FARIDKOT. So Maharaja Harinder Singh Barar was the last ruler of FARIDKOT, who was born in 1915 and died in October 1989. His only son Harmohinder Singh and his wife Rani Narinder Kaur had died earlier. At the time of his death, he was survived by his mother Mohinder Kaur and three daughters, Amrit Kaur, Dipendra Kaur and Mahipendra Kaur, and a brother Kumar Manjeet Inder Singh. So of the three daughters, only the eldest Amrit Kaur survives. The court ruling uphold her the property rights and the rights of the heirs of the other women in the family too. So let us talk about what happened to the property. So the FARIDKOT state surrendered sovereignty and joined the Patiala and East Punjab states in State Union in 1948. So the Maharaja was allowed to retain the certain personal properties spread over the FARIDKOT, Chandigarh, Shimla and Delhi. When he died, his daughter had no inheritance right, as was the norm under the feudal system. On the basis of purported will dated June 1, 1982, the Maharwal Khewaji Trust took over the property, estimated to be worth of rupees 25,000 crore. So another London-based trust, Grindlays Bank, is its sole trustee, created by Barar, was meant to provide for the three daughters. Dipendra Kaur and Mahipendra Kaur held offices this trust as chairperson and vice chairperson, and in accordance with the 1982 bill. Amrit Kaur was not part of the trust. She was disinherited and allegedly for the reason that she had married against her father's wishes at the age of 18 in 1952. So let us talk about what is the dispute about. So in 1992, the Amrit Kaur challenged the 1982 bill in the Chandigarh court. She sought 1/3 share in her father's property with consequential benefit to her sister under the Hindu Succession Act 1956. Later, she claimed the whole property, citing certain clauses in the Raja of FARIDKOT State Act 1948. So Kumar Manjeet Inder Singh, Barar's brother, also filed a suit that claimed the property, citing the rule of primogeniture. So the Dipendra Kaur and Mahipendra Kaur also questioned Amrit Kaur's claim and the will legally. So in 2013, the Chandigarh court divided the property among the two surviving daughters and declared the 1982 will as invalid. The matter then went to the lower appellate court. It upheld the decision in 2018, after which case reached the Punjab and Haryana High Court. So let us talk about how did the High Court rule on the property. So High Court not upheld the rights of the daughters and gave Barar's mother, who was alive when her son died, her share in the property. X. The Amrit Kaur had laid claim to the whole property on the basis of Section 4 and Subsection 3 of the 1948 Act. This Act states that in absence of the male descendant or his legitimate descendant, the property would go to the nearest agnate. The High Court held that the 1948 Act was not an existence enactment at the time the Constitution came in force, and the matter would not be covered under the Hindu Succession Act 1956. So will not apply to any state. This act won't apply as the descent or to a single heir of the terms of any agreement entered into by ruler of any Indian state with the Indian government or by terms of any law passed before its commencement. So primogeniture law. The Kumar Manjeet Singh argument regarding the applicability of the rule of primogeniture was also rejected by the High Court. Under the rule, the eldest male child gets the inheritance of the death of the father. Since Barar had no surviving son, Manjeet Singh argued the property must be given to him, as he is the sole surviving male descendant from the line of his and Barar's father. The High Court held that the rule ceased to exist on account of merger of FARIDKOT state with India. So let us talk about how did the court rule on the will. So the Amrit Kaur's argument was that her father was depressed on account of his son's death in 1981 and others influenced him. She said that this has resulted in a fraud and misrepresentation in the form of the will. So the forensic expert Dr. Jassi Anand, who examined the will on her behalf, proved that the will had crude symptoms of forgery. The High Court agreed with the lower court finding and held Anand has proved the forgery. So, what are the other key aspects of the verdict? So, the High Court verdict validates a will made by Barar's mother, who in 1992 had bequeathed a certain property to her other son, Kumar Manjeet Singh's kin. The High Court said that she was alive at the time of death of her son and was his class 1 IR. This makes her entitled to a share in her own son's property in accordance with the Hindu Succession Act. The question of her share hadn't been directly raised in the case before. The will stated that her personal property would go to her granddaughter Devinder Kaur and grandson Bharatinder Singh. Her will also states other than the mentioned property and estates, any other property or estate coming her way would be equally divided among Kumar Manjeet Singh, his son and daughter. So, lastly, the High Court said her inheritance cannot remain in abeyance and her lawful share is subject matter of her 1990 will. So, that's it. Thank you.